In 1925, the great state of Tennessee decided to solve one of life's most profound questions with some hastily written legislation. The Butler Act made it illegal for a public school teacher to deny the biblical story of creation. Specifically, it outlawed teaching that man descended from a lower order of animals. Nothing about microbes or plants or the vast, elegant machinery of evolution, just the bit that made people feel like distant cousins to a monkey. This wasn't a law born from careful theological debate, it was a political maneuver. And over in New York, the brand new American Civil Liberties Union saw this and thought, fantastic, let's start a fire. They put an ad in a Tennessee newspaper offering to defend any teacher brave or perhaps just bored enough to challenge it. Meanwhile, in the tiny town of Dayton, Tennessee, business was slow. A group of local leaders, including a mining engineer named George Raplia, gathered at Robinson's drugstore. They weren't debating the finer points of Genesis. They were talking about how to get people to visit their dying town. Raplia saw the ACLU ad and had a truly brilliant, deeply cynical idea. What if they manufactured a court case right here in Dayton? It would put them on the map. They weren't crusaders for free speech or religious piety. They were the original influencers, orchestrating a viral moment with telegraphs instead of hashtags. They just needed a defendant. Enter John T. Scopes, a 24-year-old football coach who sometimes filled in as a substitute science teacher. He was likable, quiet, and perfect for the part. When the town boosters approached him at the drugstore, he wasn't even sure if he had ever actually taught evolution. He'd used the state-mandated textbook, which included a chapter on it. He might have reviewed it with students before an exam. Maybe. That was enough. He agreed to be the test case, mostly because he believed in science and, one assumes, was tired of arguing. So the great legal battle for the soul of America would be fought over a lesson that may or may not have happened by a man who was primarily concerned with teaching boys how to tackle. With the stage set, it was time to cast the lead roles. For the prosecution, the World's Christian Fundamentals Association brought in a legend, William Jennings Bryan, a three-time Democratic presidential nominee, a former Secretary of State, and a titan of populist oratory. Bryan saw this as his last great crusade against the corrupting influence of modernism. The ACLU, realizing this was escalating quickly, called their own champion, Clarence Darrow. Darrow was the most famous defense attorney in America, a staunch agnostic, and a man who relished a public fight. It was a promoter's dream, the old lion of faith versus the sharp-tongued city lawyer. The press, naturally, lost its collective mind. Dayton, Tennessee got its wish. The town of 1,800 people swelled with thousands of visitors. This wasn't just a trial, it was a festival of absurdity. There were street preachers on every corner, hucksters selling Bibles and toy monkeys, and even a chimpanzee from a roadside zoo dressed in a little suit. WGN Radio from Chicago set up to broadcast the proceedings live, the first time in history a trial was ever sent over the airwaves. The courthouse was so hot and dangerously packed that the judge, John Ralston, eventually moved the whole thing outside onto a lawn. It was less a sober legal proceeding and more of a sweltering open-air revival meeting with lawyers. Darrow's strategy was simple and utterly doomed in this courtroom. He didn't care about getting Scopes acquitted. He wanted to prove the Butler Act was ridiculous by bringing in a parade of scientists to explain evolution. Judge Ralston, a devout churchgoer who opened each day's session with a prayer, wasn't having it. He ruled that the only question was whether Scopes had taught evolution, not whether the theory itself was valid or the law was good. The scientists were barred from testifying to the jury. Darrow was trying to have a debate about science, and the court was insistent on having a trial about whether someone broke a very specific, very silly rule. It was a masterclass in talking past each other. Frustrated and out of options, Darrow made one of the most bizarre and brilliant moves in legal history. He called a witness for the defense. An expert on the Holy Bible, William Jennings Bryan, the prosecutor. Bryan, brimming with confidence, agreed. For 2 hours in the brutal Tennessee heat, Darrow cross-examined Bryan on the lawn. He didn't shout, he just asked questions. Is the Bible to be taken literally? Was the Great Flood in 2348 BC? Did Jonah really get swallowed by a big fish? Bryan insisted it was all true, but under Darrow's calm, relentless questioning, he was forced to admit that maybe the days of creation weren't literal 24-hour periods. For his followers, it was a shocking, humiliating concession. The next day, the judge had the entire examination of Bryan stricken from the record. It didn't matter. The damage was done, and the radio listeners had heard it all. Darrow, having made his point, then asked the jury to find his own client guilty so they could appeal the case to a higher court. The jury obliged, taking all of 9 minutes to deliberate. John T. Scopes was found guilty of teaching evolution. His punishment? A fine of $100, which is about $1,700 today. The great battle for the soul of the nation, the clash of science and faith, resulted in a fine equivalent to a modern-day traffic ticket. Bryan had won the case, but Darrow and the press had won the narrative. The story doesn't end there. William Jennings Bryan, exhausted from the trial, remained in Dayton to give speeches. 5 days after the verdict, he died in his sleep. A tragic, dramatic end that cemented his status as a martyr for the cause. As for the verdict, it was eventually thrown out by the Tennessee Supreme Court on a technicality. The judge had set the fine, when by law, the jury was supposed to. So Scopes never paid his $100. The Butler Act, however, remained law until 1967. The ironic outcome of the Great Monkey Trial wasn't a victory for science education. It was the opposite. Textbook publishers, terrified of controversy, scrubbed references to evolution from their books for decades to avoid similar fights. The supposed victory lap actually set science education back. The Scopes trial never really ended. It just went dormant. The legal battle reemerged in the 1960s, leading to the Supreme Court case Epperson v. Arkansas, which finally struck down these anti-evolution laws. But the conflict simply changed costumes. The language shifted from biblical creation to creation science, and later the much more respectable-sounding intelligent design. The core of the debate remains exactly the same, a deep cultural anxiety about what science implies about humanity's place in the universe. We're still arguing about John Scopes' substitute teaching lesson. We've just gotten better at dressing it up in lab coats and pseudo-scientific jargon. Humans have always been great at finding new ways to have the same old arguments. You can't talk about the Scopes trial without talking about H.L. Mencken. He was a journalist for the Baltimore Sun, and his dispatches from Dayton are some of the most scathing, brilliant, and biased pieces of reporting ever written. He called the locals yokels and babbits. He famously dubbed it the monkey trial. To Mencken, this wasn't a trial about ideas, it was a spectacle of ignorance put on for his amusement. His articles shaped how the entire country, especially the urban North, viewed the event. He wasn't an objective observer, he was a master propagandist for the side of cosmopolitan modernism. Mencken's narrative is the one that has largely survived in popular culture, proving that the person holding the pen, or in this case the typewriter, often has the last word. Ultimately, every major player got what they wanted, just not in the way they expected. Dayton got its publicity, though it was mostly publicity for being a backwater. The ACLU turned a local dispute into a national platform for its civil liberties agenda. Clarence Darrow cemented his legacy as a defender of intellectual freedom. William Jennings Bryan became a martyr for the fundamentalist cause. And John Scopes? He got a scholarship to the University of Chicago, became a geologist, and worked in the oil industry. He quietly lived out his life, forever known for a crime he wasn't even sure he committed in a trial that was less about the law and more about marketing. If you enjoyed this video, please like, comment, and subscribe to our channel for more historical insights. Thanks for watching, nerds!